tato, e na mana, e na reo, e na karangatanga maha, tēnā koutou katoa. Ka mihi ki na mana whenua, koutou e pupuri ana I te mana o tēnei wahi, tēnā koutou. Ka tuku atu nā mihi rangatira ki a koe, aharangi Bain Attwood. Tēnā koe e te matanga, e hapai ana I tēnei kaupapa. E mihi nui ana ki a koe. Ke te mihi hoki ki a koe, e rangatira, e te kuia o te kura tangata. Aharangi Rewan Dalziel. Ka mihi hoki ki a koto te hunga, kua tae mai ki te tautoku I te kaupapa. Nei rā te mihi, nei rā te mihi, nei rā te mihi. Ko Greg Booth tako ingoa, ko manakura o te kura tangata o Waipapa Tamataraua hau. Nōku te honore ki te tuku I ngā mihi I tēnei pō. Me mihi hoki ki te kaupapa, hei whakawhānui ake I ngā mohiatanga e pā ana ki te tiriti o Waitangi. Nō reira, huri noa I a tātou, tēnā koutou, tēnā koutou, tēnā tātou katoa. Kia ora anō. My name is Greg, and I am the acting dean of the Faculty of Arts, and I've said pretty much everything I need to say this evening, except to welcome you all and to thank you for joining us in this unexpected mode, and to help us celebrate the life and the scholarship of Professor Keith Sinclair. I think at this point, the best thing for me to do is to turn this over to Linda Brighter, Professor Linda Brighter, who will introduce the program and our speaker. Kia ora koutou.
All right, thank you, Greg, and tēnā koutou katoa. It's my great pleasure to be introducing this year's Keith Sinclair Memorial Lecturer. Professor of History at Monash University, Melbourne, Bain Attwood has published extensively on the history of colonialism. Of interest to our graduates who have zoomed in this evening and who might be considering further studies, I note that on his homepage, Bain tells us that his supervision interests lie in the fields of Indigenous history, history and memory, and public history, and is currently working on a book about denial and Australia's Black history, funded by the Gerda Henkel Foundation. So Bain is engaging in some really exciting research. Not that we want to lose our students to across the ditch, of course, but that is the path that Bain himself took. Bain came to Auckland from Waikato to undertake his master's thesis in 1977 and completed his MA at the University of Auckland in 1979, a year before me, and I thought I was old. Sorry. Bain's MA thesis was on New Zealand's foreign relations, entitled Apostles of Peace, the New Zealand League of Nations Union. He then went across the ditch and completed his PhD at La Trobe University in 1984 with his thesis entitled Blacks and Lohans, Aboriginal European Contact in Gippsland in the 19th Century. And after that, he moved to Monash, where, as I said, he is now Professor of History. Well, Bain has an impressive list of publications, I think one can say. His sole-authored books include The Making of Aborigines, 1989, Rights for Aborigines, 2003, Telling the Truth About Aboriginal History in 2005, and Possession, Batman's Treaty and the Matter of History, intriguing titles, in 2009. The latter, in fact, won him the Ernest Scott Prize for the most distinguished contribution to the history of Australia or New Zealand that year. And more recently, he's also included Aotearoa New Zealand in his sites. His recent 2020 book called Empire and the Making of Native title Sovereignty, Property and Indigenous People, published by Cambridge University Press, was the joint winner of the New Zealand Historical Association's 2021 W.H. Oliver Prize for the Best Book on New Zealand History, and was also shortlisted for the Ernest Scott Prize. Now, his new book, which is his 9th, forms the basis of his talk this evening. That book, as you'll all be aware, is called A Bloody Difficult Subject, Ruth Ross, Tiriti o Waitangi and the Making of History, and is being published by Auckland University Press. Now, Bain brings to this study a long engagement and reflection on colonial history, race relations, and public history. And we're very excited to have him here this evening as the 2023 Keith Sinclair Annual Lecturer. And our only regret is that we are not meeting in person. Keith Sinclair, who knew Ruth Ross, the starting point for Bain's study and the springboard for his wider reflections, would have been delighted to have been here this evening to hear the account of what happened to that journal article, which he himself accepted for publication in the journal that he had established so many years ago. So welcome, a big welcome to Professor Bain Attwood, and we look very much to hearing what you have to say this evening. Thank you for coming along.
Thanks very much for that introduction, Linda. Tēnā koutou, tēnā koutou, tēnā koutou katoa. It's a great honour to be invited to give this lecture commemorating the work of one of this country's finest historians, Keith Sinclair. We have, as has already been said, hoped that we'd be able to meet in person, but as those who live in Auckland know, it's been raining cats and dogs here today. But I guess the upside is those outside of Auckland are able to tune in if they.
Turn your mic on, Bain.
And translations, little anticipating that it would play a pivotal role in the transformation of public understanding of the Treaty of Waitangi and its status in New Zealand law, politics, culture, and history. In this lecture, I want to consider how and why this happened and contemplate what it reveals about the connections that often occur between what I call in my new book. Still having technical problems. Sorry. In my new book, A Bloody Difficult Subject, Ruth Ross, Tiriti o Waitangi and the Making of History. But what I want to contemplate here is the connections that often occur between what I call the cloistered, public, and private lives of history. I should perhaps say here that in my book, I'm seeking to make sense of Ruth Ross's history of the treaty and the story that others have since told about it, rather than, if you like, arguing the toss about the merits or otherwise of her interpretation of the treaty. As you're about to get some sense of, the story I tell, which seeks to provide, if you like, a genealogy of Ruth Ross' now famous journal article, and the treaty itself in recent times, is, I think, full of surprises, of unforeseen circumstances, unexpected turns, and unanticipated outcomes. This is true of Ross's authoring of this famous article in the New Zealand Journal of History in 1972, but also the reception of it, both of which I'm going to talk about here this evening. But before I go any further, a word or two about what I'm calling the cloistered, public, and private lives of history. The cloistered life of history and the public life of history are concepts that I've borrowed from the renowned post-colonial historian, Dipesh Chakrabarti. The private life of history is my own formulation. By the cloistered life of history, Chakrabarti means the life that the discipline of history enjoys in universities, like this one, as it is taught, studied and researched, discussed and debated in academic seminars, conferences, journals, monographs, and the like. By the public life of history, Chakrabarti means the discussions and debates that occur about history in the public domain. The relationship between the public and the cloistered lives of history, Chakrabarti points out, is often an awkward and tense one. In the New Zealand case, nowhere has this been more evident than in the conversations and controversies about the Treaty of Waitangi. By the private life of history, I primarily mean the ways that history works as an emotional force in the lives of its practitioners, in the lives of historians. I've adopted this concept, the private life of history, to highlight the role that psychological forces, often unconscious and irrational in nature, play in the practice or work of any historian. Usually, academic historians are unable to get much sense of this, the private life of history. But in Ruth Ross's case, we have a remarkable archive, mainly comprising of her letters, that enable the historian to examine the influence that the private life of history had on her work on the treaty. Ruth Ross's 1972 Journal of History article might be said to have begun its life as a seminar paper, a paper she presented in February 1972 at a two-day seminar on the treaty that was held at the Victoria University of Wellington. This is not an academic seminar in the sense of a seminar that was conceived, organised, and held in the academic cloister of a university department of history. Instead, it was a public seminar that was staged by the part of the university that was responsible for public programs. Victoria University had only recently created its Department of University Extension, no doubt in response to the fact that its academics were no longer engaging in public debate as a matter of course, or at least not as much as they had done just a generation earlier. The brief of this part of the university was to stage occasional seminars in which information about and interpretation of important public issues was presented, largely by scholars, in the hope that this would deepen public understanding of important contemporary issues. In this case, the Victoria Department of University Extension decided to hold a seminar on what it called, as you can see here, the Tiriti of Waitangi, the Treaty of Waitangi, because it recognised the treaty had recently become a subject of enormous public interest and debate. That interest was partly the result of an ongoing campaign by the 4 Māori MPs to raise the profile of Waitangi Day and to get the treaty ratified, in other words, made part of New Zealand law. But it was mostly the outcome of protest by young urban Māori, and particularly members of Ngā Tamatoa, the Young Warriors, a group which had recently been formed after a Young Māori Leaders Conference, as it was called, at this university. Ngā Tamatoa and other radical groups contested the celebration of the treaty as they attacked what they saw as the myth that New Zealanders were one people and the claim that the country's race relations were the finest in the world. They damned the treaty as a fraud and a sham, as you can see from this badge, which dated from just a few years after this. Just as the seminar at Victoria University in February 1972, where Ross gave the paper that became her famous article, just as that seminar was not an academic one, in the sense that it was not an expression of the cloistered life of the university or of history, Ruth Ross was not an academic historian in the sense of a historian who held an academic position. She did have an academic training in the discipline, being one of the first generation in New Zealand to receive such training. In her case, in the late 1930s and early 1940s, at Victoria University. And you can see here a photograph of her taken around the time that she started her studies at what was then called Victoria University College in 1939. Ruth Ross was what we would now call a public historian. That is, an academically trained historian who does their research and writing outside the academic cloister, outside the walls of the university, often for public bodies such as government departments. In fact, Ruth Ross was first engaged as a historian in the early 1940s by the historical branch of the Department of Internal Affairs. And you can see her here at work, a photo taken, I believe, in around 1944. Practically all the work that Ruth Ross did on the Treaty of Waitangi across many years, and this was work that began in the early to mid-1950s, if not a decade earlier, all the work that Ross did on the treaty was the result of her receiving commissions from state institutions or invitations from other public-facing bodies. And those commissions and invitations, I argue in my book, had a profound influence on the nature of the work she did on the treaty. The most important example of this, I think, is the first major piece of research Ross tried to do on the treaty. In 1953, her teacher, mentor, and patron at Victoria University College, J.C. Beaglehole, arranged a commission for her from New Zealand's government printer. She was tasked to write a new introduction for a small book first published in 1877. This book, the title of which you can see here on the screen, primarily comprised of facsimiles, in other words, exact copies of versions of the treaty in both English and Te Reo Māori, versions of the treaty that Ross came to call the texts of the treaty. In Ross's view, the very terms of this commission, this government printer commission, that it was for a publication that featured those facsimiles, featured those texts of the treaty, required her to pay what was an unprecedented amount of attention to the texts of the treaty rather than, say, the contexts in which it was made. What Ruth Ross called her textual approach to the treaty came to typify nearly all of the work she did on the treaty, which includes her famous 1972 article, entitled in part, as I said before, the Tiriti of Waitangi Texts and Translations. But to return to that Victoria Department of University Extension weekend seminar in February 1972, I think it's worth noting that it was a public historian who was invited to be the principal historian to talk about the treaty, in other words, Ruth Ross. And had it not been Ruth Ross, it would almost certainly have been this man, Ian Wards, another historian like Ruth Ross, who'd been trained in the discipline of history, but also worked outside the academy. This was the case because in 1972, no historian working in a New Zealand university had sufficient expertise to discuss the treaty because none had actually undertaken an extensive study of it. Even at the end of that decade, even at the end of the 1970s, Claudia Orange had to persuade her two supervisors at this university, one of whom was Keith Sinclair, that it was worth her while embarking on a PhD thesis on the treaty, which then became the famous 1987 book, the Treaty of Waitangi. What I'm trying to get at here is that the publication of Ruth Ross' Victoria University seminar paper, or a version of it, in the academic journal, the New Zealand Journal of History in October 1972, can readily lead us to assume that her article was the product of the cloistered life of history. But this, at best, I argue, is only partly true. For all the fact that her famous article is undoubtedly a piece of historical scholarship written by someone trained in the discipline of history, it is also a piece of work that was profoundly shaped by what I'm calling the public life of history. This, I think, is evident in the opening paragraph or passage of this journal article of 1972. She wrote, as you can see here, in submissions to the Parliamentary Committee on Fisheries in 1971, the New Zealand Māori Council pressed for the recognition, observance of the Treaty of Waitangi in relation to the protection of Māori rights and their traditional sources of shellfish and fishing beds, after which she remarked, "This is a fairly typical example of the sort of statement being made about the treaty by politicians, Māori organisations and other interested parties." Ross had a good deal of trouble working on her Victoria seminar paper. By the early 1970s, she hadn't done much work on the treaty for close to 10 years. As I said before, she does her original work on the treaty, in some ways her most important work, in the 1950s. And she made the task of writing her seminar paper more difficult for herself. She could have revised a paper she had presented in Wellington more than 15 years earlier, in other words, in 1956. But, always the professional, she decided to start more or less from scratch and to do more research. The writing itself proved a real struggle. I don't think perhaps before we resume, I should say that one of the senior lecturers in the program here, Zizek, has been a wonderful force today, making sure this is possible, and he's kept very calm in this situation, more calm than I would have been able to, and so we've sorted the problem. The security alarms have been turned off, and we can proceed. So I was in the middle of saying that Ruth Ross found writing the seminar paper in the early 1970s, the seminar paper that led to her famous article, really quite difficult. She hadn't worked much on the treaty for something like 10 years by that stage, having done most of her major work on it in the 1950s. The writing itself proved a real struggle. She said in a letter to one of her correspondents, "I don't think I've ever found anything so difficult to write as this ruddy Waitangi thing." But after a good deal of hard work, she got there. And when she gave her paper, she was very anxious about getting it, very nervous, but she got a very good reception. or at least it did from many of the Pākehā at this weekend seminar. Māori members of the audience were more critical. After the seminar, Ruth Ross gave some thought to getting her paper published, but she felt it needed more work. There, the story I'm telling in this lecture might have ended, but for the role played by two men, let's call them two knights in shining armour. The first of these two men was Ormond Wilson, the former chairman of the Historic Places Trust, where he was a colleague and sparring partner of Ruth Ross, and like Ruth Ross, an amateur historian in the sense that he did his historical work outside the academic cloister. As Ross had worked on her seminar paper, Wilson had simultaneously undermined and encouraged her. But shortly after she presented it, he took the trouble to write to our second knight in shining armour, Keith Sinclair, to tell him about the excellent paper that she had given. Sinclair, the doyen of New Zealand's post-war academic historians, had been a driving force behind the establishment of the New Zealand Journal of History in the Department of History at this university just a few years earlier, 1967. He had formed the opinion that there would never be truly probing scholarly history in this country unless there was a journal devoted to publishing it. Up until this time, most New Zealand historians had had to make do with submitting their work across the ditch to an Australian journal. The fact that Sinclair took an interest in Ruth Ross' seminar paper is probably unsurprising. At the time, there were relatively few academic historians working exclusively in New Zealand history, and so the New Zealand Journal of History, that he had played a major role in establishing, struggled to fill its pages with work on New Zealand's history. Sinclair also had a considerable interest, though, in the history of relations between Māori and Pākehā. He had done his earliest research on the subject, most notably a landmark study of the origins of what was then called the Anglo-Māori Wars of the 1860s, and he had written a brilliant short history of New Zealand that made that conflict, and race relations as it was then called, central to the story of New Zealand's past. More especially, he had some interest in the Treaty of Waitangi, and he had argued in a recently published article in 1971 that the treaty was one of the reasons that race relations were better in New Zealand, he argued, than any comparable settler society. What's more, Sinclair had discussed the treaty with Ross nearly 20 years earlier when she had embarked on her first sustained work on it, that government printer commission, and he had encouraged her to persist, and over the years he had read drafts of some of the pieces she had written about it. He admired her scholarly rigour. Her historical scholarship was the kind of work that met the call he first made in 1950 for a generation of pedants, historians who would do an enormous amount of research and proceed very empirically. And he'd once told her, this was in 1956, he'd once told Ruth Ross, somewhat tongue-in-cheek, that he regarded her as the sternest perfectionist in New Zealand. Given this last point, what Sinclair called Ruth Ross' perfectionist streak, given this, he knew, I think, that it might be difficult to get an article out of her. And Sinclair was not alone in this regard. A few years earlier, her teacher, mentor and patron, J.C. Beaglehole, had made this remark about Ross to an acquaintance in England. "There's another person out here like you," he said. "She knows more about certain things than anybody else. She's capable of brilliant work, as when she writes a memorandum without thinking about it, or a letter denouncing somebody else. And yet we're all dead scared she'll slide into the grave and leave undone all the terrific work she could do." And so, shortly after Sinclair learned from Ormond Wilson of Ross's seminar paper, he sent her a letter saying, "If you do not think it yet ready for publication, could I, at any rate, have a preliminary look?" Fortunately, Ruth Ross agreed to his request. She had enormous respect for him. And they were also very similar in many respects. Both had enormous energy, curiosity, and honesty, and both loved a good argument, which they were soon to have. After reading Ruth's seminar paper, Sinclair decided to commission two of his colleagues to read it for the New Zealand Journal of History. The Māori linguist, Bruce Briggs, pictured on the left here, who had given Ross advice about the Māori text of the treaty nearly 20 years earlier, and the historian Judith Binney, who you can see on the right here, who knew Ross well and had drawn heavily on her knowledge about pre-1840 Northern New Zealand for a study she'd done of the missionary Thomas Kendall. One of Sinclair's professorial colleagues, Keith Sorensen, who was the journal's assistant editor, and who has similarly cut his research chair with work on the history of relations between Māori and Pākehā, also read and commented on Ruth Ross's paper. On sending Ross these readers' reports and his own comments, Sinclair took the trouble to provide her with the encouragement he realised she needed, going so far as to tell her that once she'd revised her paper, and I quote, "It will probably be the most important article which has been submitted to us." He also told her to revise it as she saw fit, and even to go over length if necessary, though he begged her, please don't turn it into a book. In effect, Sinclair would ensure the publication of Ross's article by shepherding it through each of the stages that a paper has to go through before being published by a scholarly journal. Bruce Briggs' readers' report, and more especially those of Judith Binney and Keith Sinclair, played an important role in shaping the revisions she did to her paper to turn it into an article. This was more by accident than design, I think. Their responses both prompted and provoked her to place more emphasis on the treaty texts than she had done in her seminar paper, or at least this is what she believed she did in revising it. What happened, as I'm about to demonstrate, owes a good deal to what I've called the private life of history. Ross was greatly encouraged by Bruce Briggs' brief readers' report, which had focused on the argument she had made in her paper about the way the English text of the treaty had been translated into Māori. She told Sinclair, "I have always been very conscious of how ill-equipped I am to tackle Waitangi this way," in other words, by focusing on the Māori text. "There are," she said, "so many pitfalls, and it's been a hard slog." Remember what I said, that she started this work in the mid-1950s. If Bruce Briggs thinks what I have to say on the Māori text is worth publishing, then I feel I've really passed the test. This clearly mattered a good deal to her. As she told Sinclair, she had been determined to focus on the treaty texts in her seminar paper, calling this a matter of sticking to her guns. "You see," she told him, "years ago, this was in 1956, I gave a seminar paper to the history people at Victoria on the subject of the treaty, and it was intimated to me that my textual approach was a waste of time. I didn't agree, but accepted that academics had no use for it. And so I tossed in the work I was supposed to be doing for a reissue of the facsimiles by the government printer. Well," she mused, "fashions change. The reaction of you Auckland University people to my paper buoys me up no end. It makes me feel I'm no longer such a nut on the subject of the treaty." Yet, as I've said, Ross was not only prompted by her readers' reports to make more of her textual approach to the treaty, or so she thought. She was also provoked to do so by these reports, or at least those by Sinclair and Binney. How was this so? Some of what they had to say about her seminar paper convinced her that they had misunderstood one of her key arguments, namely that the Māori text, rather than the English text, was what she called the treaty. Their misunderstanding of her work, if this is what it really was, caused a repetition in Ross's mind of the uncomprehending response she had received to that paper she had delivered in Victoria in 1956, and the feelings of despair and rage that she had felt on that occasion when it had been attacked and rejected. This made her all the more determined to place more emphasis on the treaty text, or so she thought. She told Sinclair, "You say in your letter, we at the journal are inclined to think that it might be useful to publish the text in English and a literal English translation from the Māori in the appendices to your article. I'm sorry, I don't agree. What you call the text of the treaty in English is not the Treaty of Waitangi, but just the treaty that was signed at the Waikato Heads. I strenuously object to publishing any English translation of the Māori text because, damn it, this is what half my paper is about, the meaning of the Māori text." As you can probably tell, at least in her letters, Ruth Ross swore a great deal, which is where I get the title of my book, A Bloody Difficult Subject, from, because this is what she said at one point. It seems that Ross was also glad to place more emphasis, at least in her mind, on the treaty texts, and especially the Māori text, because another episode had returned to her mind or heart that she had found just as difficult as the rejection of her textual approach by historians at Victoria in 1956. As I indicated earlier, at that same time, 1956, she had abandoned the Government Printers Treaty Commission that she had sought to execute by focusing on the treaty texts. Abandoning that commission had long troubled her, in part because she felt that she had let J.C. Beaglehall, her teacher, mentor, and patron, down by tossing in the commission he had arranged, in part because she felt he had let her down by failing to provide her the guidance and encouragement she felt she needed in order to pursue this textual approach, which, as I've said, was unprecedented at that time, and indeed for quite a long time. This textual approach to the treaty, and particularly the focus on Māori text. I think there can be little doubt that the remorse and anger she felt about that episode with Beaglehall in 1956 had been heightened by Beaglehall's recent death, which had saddened her enormously. And this led her, in her mind at least, to try and emphasise her textual approach in what became her famous article. As Ross said about revising her paper for publication in the journal, she found, once again, the going tough. In April 1972, after she had received the readers' reports of her paper from Sinclair, she poured her heart out to her younger son, Malcolm. I wish thinking came more easily to me, or put it more crudely, I wish I was not so damned dumb. When I said this not so long ago to Father Simmons, who was a Catholic priest, he asked, what made me think I was dumb? And I said, okay, maybe not exactly dumb, but I'm so bloody slow. If I slog at it, sometimes I get there in the end. But if and when I do, it's usually in a state of exhaustion. Ross had some sense the difficulty she was having in revising her paper for publication was a function of the originality of her textual approach to the treaty. But she found this little consolation, telling Malcolm, I just sit down and slog away, ploughing through the underbrush and finding my own way out in the end. But it's that finding my way out that is such slow torture. Anyone else, I always feel, given the same material, could have sorted it out in half the time and with only a tenth of the self-torture, and would have made much more readily intelligible that. Of course, in the end, the feeling of achievement is out of all proportion to the thing achieved until one by one, the errors come home to roost, and you want to curl up and hide in a very small hole somewhere. And then in my affliction and misery, remembering only the wormwood and the gall, a misquotation from somewhere surely, I wonder why the hell I ever try and do anything but grow cabbages. Ross was too hard on herself, as she always was, not least because on this occasion she had barely misquoted this passage. It came from the Book of Lamentations. I remember my affliction and my wandering, the bitterness and the cold. In the months that followed in 1972, Ross complained on several more occasions of the difficulty she was having struggling with her article. In May, she told Sinclair, the treaty's a bloody difficult subject. I wish I'd never strayed into it. In July, she told the Hocken librarian, Michael Hitchens, who was trying to help her with the manuscript sources she wanted to consult, I'm becoming more and more exasperated and bored and hag-ridden by it. The toll it was taking on her was not only psychological, but physical. Battering the typewriter virtually non-stop for a month, she told Orman Wilson, has produced an acute case of tennis elbow. Nevertheless, Ross was determined to meet the deadline that Keith Sinclair had given her. And all the more so because Beverly Simmons, the administrative assistant in the Department of History at this university, had told Ross in confidence that Sinclair was not expecting her to submit on time, and Ross wanted to prove him wrong. A few days into August, she took her revised article into the department and triumphantly presented it to him. I don't believe it, he apparently said. Sinclair accepted Ross's article for publication, even though at 14,000 words, it was much longer than the articles the journal usually published. Moreover, he did not require her to make any major changes. Ross must have been bemused. She was accustomed to having to revise her work repeatedly for less scholarly journals and the like, such as those at the school publications branch of the Department of Education, where the poet James K. Baxter once acted as the editor for one of her most important publications in the treaty. A couple of difficulties did arise before her article was published. Ross had to deal with numerous copy editing queries when she had her hands full taking care of two toddlers who belonged to her husband's niece. Like most women of her generation and many since, Ross was forever having to juggle her scholarly work and her familial responsibilities. Then, having answered those queries, the journal delivered to her a set of galley proofs in which Judith Binney and one of her professorial colleagues, Nicholas Tarling, had corrected her referencing by using stylistic conventions that were radically different. One of them had marked her proofs up in blue ink, the other in red, as I say, using different stylistic conventions as far as referencing is concerned. Ross was not pleased. She insisted on seeing Nicholas Dale about the matter. She told Ormond Wilson, "We had a very sparky session, which I think he quite enjoyed. The nicest touch was when we reached perfect agreement on how British parliamentary papers should be cited. That's the way I had it," she said, but then Mrs. Binney buggered it all up. He said this, Ross said, in a very plum English accent. It was really delightful. I should say here, perhaps as a digression, that Ross and Binney had once been close, had long correspondence, but by this stage, they had, for various reasons, some which relates to the tension between what I'm calling the public life of history and the cloistered life of history. And I think there's also tension between them because they belong to quite different generations of New Zealand women. But that's a story I tell in the book, and if you're interested, you can read it there. So turning now to the substance of Ruth Ross's 1972 article in the New Zealand Journal of History. It's often said that the principal argument of this famous article is that there were substantial differences, or there are substantive differences between the Māori text and the English text of the treaty, that the Māori text constituted the treaty, and that any consideration of the treaty's meanings and implications should proceed on that basis. And yet a careful, or even a cursory reading of her article brings that assumption or belief into question. Ross did argue that there were radical differences between the two languages texts, but to her way of thinking, these differences merely constituted the best evidence for what was actually her principal argument, an argument that she expressed in a passage that appears in her article as she began to bring it to a close. Ross wrote, as you can see here, "The Māori and Pākehā signatories of 1840 were uncertain and divided in their understanding of the treaty's meaning. Who can say now what its intentions were? However good intentions may have been, a close study of events shows that the Treaty of Waitangi was hastily and inexpertly drawn up, ambiguous and contradictory in content, chaotic in its execution. To persist in postulating that this was a sacred compact," she said, "is sheer hypocrisy." Her argument about the treaty texts, and the Māori one in particular, were inextricably bound up, I think, with an argument she had made about translation, or rather what she saw as mistranslation of the English text into Māori. It's this argument, I think, that underpinned her principal argument. She argued that the treaty was ambiguous and contradictory because, she believed, the English text had been mistranslated into Māori. It was for this reason, she argued, that the parties to the treaty were uncertain and divided about its meaning. And this was the reason she concluded that it could not be regarded as a moral compact, let alone as a legal contract, given that such a thing requires agreement about its terms among the parties to it. So it was that Ross went on to say in her concluding remarks about what she called the Waitangi problem. Ever since the 1840s, the New Zealander has been told that the Treaty of Waitangi was the Māori Magna Carta. In modern times, the Governor-General, Lord Vladislaw's prayer has been repeated each Waitangi Day that the sacred compact then made in these waters may be faithfully and honourably kept for all time to come. Yet she said, how many of today's New Zealanders, Māori or Pākehā, ever look at the Treaty of Waitangi? To each one of us, the politician in Parliament, the kamatua on the marae, the tamatoa in the city, the teacher in the classroom, the preacher in the pulpit, the Treaty of Waitangi says whatever we want it to say. Given that this was her principal argument, as she expressed it to Sinclair when she submitted her article, my only theory is that the whole exercise of making the treaty was an absolute shambles. Given that was her principal argument, it is somewhat surprising, I think, that her article came to be entitled, as it was, Te Tiriti o Waitangi, Texts and Translation. This was not Ross's title for her article. She called it, as you can see here, A New Look at the Treaty of Waitangi. It was Keith Sinclair and Judith Binney who were responsible for the article's title. Perhaps they were merely following the way Ross had characterised her article, or rather mischaracterised it when she had submitted it. She claimed that she had confined herself to a discussion of the texts and the treaties. She had done no such thing. So why did Keith Sinclair and Judith Binney give her article that title? Perhaps they were unconsciously influenced by the angry remarks Ross had made, which I reported before, when she felt they had misunderstood her argument about the Māori text. Whatever the case, the titling, or what we might call the mistitling of Ross's article, probably owes something to what I've called the private life and history. Now, this matter of the journal's title matters, I think, because it probably played some role in how Ruth Ross's article came to be read or received in the fullness of time, as I will discuss in a moment. Before doing this, it's worth observing that Ross was deeply ambivalent about her famous article. While she was delighted to have an article about the treaty accepted by an academic journal, she was by no means enamoured by the focus she felt or believed it had ended up taking. On submitting it to Sinclair, she told him, "I'd like to do another article for the New Zealand Journal of History about who signed the treaty, why and what it signified to them, and so on." By that she means the Māori who signed the treaty. Much more interesting and much more fun than all the scrutinising of various texts and translations and what have you, she said. In other words, Ross wanted to do more work on what she saw as the Māori perspectives of the treaty. So far, I've largely been talking about the production of Ross's famous article, but now I'm going to largely switch to talking about its reception. And by its reception, I mean the way in which a text is received or read or interpreted. Most articles published in academic journals are, as you know, only read within the academic cloister. But this was not the case with Ruth Ross's article, and this was true from the outset. Shortly after the issue of the journal in which it appeared was published, in December 1972, the journal's business manager, a lecturer here, Anthony Wood, told Ross that one of his neighbours had borrowed an off-print of it and was so fascinated by it that they had not done their household chores that day. 2 months later, Ross's article featured in a review of the journal, that journal issue, that appeared in one of the local newspapers, the Auckland Star. In the next several years, her article was widely referenced by other Pākehā historians, both inside and outside the academic cloister, including, most notably, Tony Simpson in his Te Rere Pākehā, The White Man's Anger, and John Owens in an essay he published in the Oxford History of New Zealand. Both these historians, as well as other historians, read Ross's article in terms of what I've been calling its principal argument. This was in keeping with the attacks that have been launched against the treaty, both by Māori and Pākehā radicals since the early 1970s, as a sham and a fraud. This reception or reading of Ross's article is no more evident than in the cartoon by Bob Brocky that appeared in the National Business Review in February 1982. In its top right-hand corner, as I trust you can see here, he quoted Ross's principal argument. Okay, the treaty is hastily and explicitly drawn up, ambiguous and contradictory in content, and chaotic in execution, and so on. Shortly after this cartoon appeared, Brocky told of how he had heard these words of Ross's being bandied around a dinner table, and he remarked that Ross, as, in his words, the inspired author of this universal put-down of the treaty, must be gratified to see her words passing into the New Zealand vernacular. But this was not the only way in which Ross's article was being read, or could be read, and this is not the reason why it can be said to be famous. It became famous because it came to be read in terms of its argument about the Māori text as the treaty and the differences between that text and the English text. In other words, it came to be read in terms of what I'm calling its other argument, not its principal argument, but its other argument. Why, I want to ask, how and why did the reception or reading of Ross's article change so dramatically? From the way in which, if you like, the likes of Bob Brocky, the cartoonist, and many radical Māori and Pākehā readers received it in the 10 years after Ross published it. Why did it change so dramatically from that to a different way of reading it? The answer to this question, I think, lies more in the realm of the public life of history rather than its cloistered life. In the first instance, Ross played some role in the very different way in which her article came to be read. She played a role, however, unintentionally or inadvertently. In January 1973, that is shortly after her article was published, she sent off prints of it to two of the Māori MPs, Matt Rata and Whetu Tirakapani Sullivan, who had recently become ministers in the newly elected Kirk Labour government. And later the same year, she sent her article to two important Māori advocates, Bob Mahuta and Henry Ngata. All of these people, by the way, Ross knew personally, if only to a small degree. Consequently, her article, first in the mid-1970s, but more importantly from the early to mid-1980s, came to be read by legislators, legal scholars, and lawyers in a way that diverged enormously from the way it had been received by historians in the 10 years after it had been published. To explain how this happened, and this is something I discuss at considerable length in the second part of my book, it's useful to draw on reception theory, the essence of which I think can be distilled like this. Many people tend to assume that readers will read or understand a text or a piece of work in accordance with an author's intentions. And when that doesn't occur, it's commonly believed that this amounts to a misunderstanding and a distortion of the text or piece of work in question. Furthermore, that misunderstanding and distortion is often attributed to some problem or other in a process of communication that is otherwise assumed to be unproblematic. And yet, in most societies, the way a piece of work or a text is read or received or interpreted is seldom in keeping with an author's intention. And this is so because texts, by their very nature, are open to being read or understood in multiple ways. It's also a mistake to assume that any text, like Ross's article or the Treaty of Waitangi itself, amounts to a coherent or unitary whole. Instead, it's best to acknowledge that within many texts there are ambiguities and tensions. Indeed, one of the reasons why a text like Ross's and texts like the treaty have become canonical or famous lies in those very characteristics, that they are ambiguous and they have tensions within them. And so the history of texts like Ruth Ross's article and the treaty itself is a history of the divergent and even conflicting readings and different uses to which those texts are put by their readers. I expect you have already gathered from what I've been suggesting is that Ross's article had at the very least two very different argumentative threads that don't constitute a coherent whole and which can be readily severed from one another by a reader and therefore made to stand alone. On the one hand, it can be said that she argued that the terms of the treaty were ambiguous and that its signatories were uncertain and therefore divided about its meaning. And on the other hand, it can be said that she argued that the text in Māori was the treaty and that Māori perspectives of it should be recovered and understood. In my book, I've suggested that there might be two ways in which we can think about this reception, these widely divergent ways in which Ross's article is read. First, I suggest that we could regard the first of Ruth Ross's argument, her argument which I call her principal argument. We could think about this as being the text of her article, and we could think about that other argument as its subtext. And here the word text are meaning to stand for the forces that she was conscious of, or which she knew was shaping her principal argument. And I'm using the word subtext for the forces that shaped her other argument that lay in what we might call Ross's subconscious or unconscious, and as a result, she wasn't fully cognizant or conscious of. Second, I suggest that it might make sense to call the first of her arguments her major argument, and the second one her minor argument. The words major and minor being used here by myself, not so much in the sense of their meaning of greater and lesser importance, but rather more in the musical sense, that a piece of music can switch readily from a major key to a minor key, and in doing that, immediately lend to the same melody or idea a different character or a different emotion, therefore influencing its reception. And so what I'm suggesting is that various people across time have read it either in its major key or its minor key, and I'm trying to explain how that could happen quite easily. What I'm suggesting here then is that the divergent ways in which Ross's article has been read can be attributed to the text itself. But how a text is read also depends enormously on the context in which it is read. And I want to suggest that this is mainly responsible for the dramatic shift in the way Ross's article was received or read or interpreted from the early to mid-1980s. The new context in which Ross's article and the treaty itself were read from this time onwards, from the early to mid-1980s, can be loosely characterised as legal, political, and Māori, and primarily in terms of the role played by the Waitangi Tribunal under the leadership of Eddie Jury, who you can see pictured here. In this context, Ross's article was read in terms of what I've called her minor argument, that the provisions of the text in Māori and the English language texts are very different, and that the real treaty is the Māori text. And consequently, the treaty in turn came to be interpreted and hence understood in this way. To be more specific, Ross's article is now read by lawyers in terms of a suggestion that she had tentatively made in her article, that in the Māori language text, Māori had not ceded Te Tino Rangatiratanga, or sovereignty, to the British Crown, but merely kawanatanga, or governorship, and that Māori had not only retained Te Tino Rangatiratanga, or full chieftainship in respect of their land, but also in regard to their te ona, or possessions. As Ross's minor argument was picked up by the tribunal, Te Tino Rangatiratanga, kawanatanga, and te ona came to be regarded as the treaty's key words or terms and fundamental to an interpretation of it as a binding legal contract between the Māori and the Crown. In contrast, most lawyers had no use for what I'm calling her major argument, that the treaty was ambiguous, confused, and contradictory. This was put aside or cast aside in most legal readings of her article. Here I want to emphasize that whether it's the difference between the two language texts or whether it's the similarities between the two texts that is held to be more important is not something that can be determined or can be determined on empirical grounds. After all, differences and similarities are everywhere in the world, but which ones are deemed to count is determined not on empirical grounds, but instead by social, cultural, and above all else, political considerations. Just to make that easy to understand, if you look at the image on the screen here, you have a choice of whether you say, well, what you can see on the screen, the objects there are basically similar. They all have the same shape. Or you could choose to emphasize the differences of the objects in terms of their colors. And what I'm suggesting is whether you emphasize the different colors of these objects on the screen, or whether you emphasize that they have the same shape, is not something that is determined on empirical grounds. It's determined, as I've said, by social, cultural, and above all, political considerations. And the history of the treaty testifies to this point. In the last 7 decades, there have been swings back and forth. At one moment, the emphasis has been on the similarities between the two texts. At another moment, the emphasis has been on the differences between them. And then recently, in the work of one scholar, the emphasis has been on the similarities. Moreover, there are some scholars who at one point have argued for the similarities, and then at another point of time have argued for the differences. What did Ross make of the fact that her article in the treaty itself came to be interpreted in terms of her minor argument, and thus in a way that she cannot have expected, as it was contrary to her intentions in writing her famous article? We can't know for sure, because she died relatively young in 1982. She died, in other words, shortly before the changes in the reception of her article and the interpretation of the treaty I've been describing became evident to anyone in New Zealand, really, let alone to her. Nonetheless, I think we can probably have a pretty good idea of what Ross would have made of these changes. She would have been amazed by the fact that her article had become so influential. She was a modest and retiring woman. But putting this aside, it seems that she would have been both puzzled and troubled by the way her article had come to be read by lawmakers, lawyers, and legal scholars. It also seems likely that she would have been astounded by the phenomenal rise in the treaty's legal status, and nonplussed that this resulted from the fashioning of what she would have regarded as a new myth about it. I say this because a fair part of her life's work on the treaty was, it can be said, devoted to destroying what she regarded as the myth about the treaty as New Zealand's Magna Carta. I suggest what I've just suggested because it's something that happened shortly after her article was published in 1972. A legal scholar at this university, Francis Orban, having read her article, wrote a letter to her to alert her to a short article he had recently published about the treaty, which was entitled the Treaty of Waitangi, the Treaty of Waitangi in New Zealand law. Orban wanted to engage Ross in conversation about the legal meaning and status of the treaty. He was part of a new generation of legal scholars in New Zealand who had recently begun to be influenced by and to contribute to profound changes in legal theory, practice, and history internationally regarding the sovereignty and rights of property of Indigenous people in Canada, Australia, and New Zealand, as well as the historical treaties that the British Crown had made in Canada and New Zealand. As the title of Orban's article might suggest, he was essentially arguing, contrary to recent generations of New Zealand lawyers and legal scholars at the time, he was arguing that the treaty was a valid agreement according to both domestic and international law. But Ross was puzzled by these new developments and legal interpretations of the treaty. While she realised that her article might be put to some political end, indeed she hoped it would be, she assumed there were no grounds whatsoever upon which the treaty could be recognised in New Zealand law, largely because she held that the parties to it, as I've said, were uncertain and divided in their understanding of what it meant. Indeed, she was scathing about one of the arguments that Auckland had made in this article. In it, he had contended at one point that the treaty had been recognised in international law a long time ago as a result of a long-running case heard by the British American Claims Tribunal involving claims to land. As far as Ross was concerned, what lawyers had said on that occasion, the occasion of this British American Claims Tribunal, and what this lawyer, Auckland, was arguing now, according to her, this amounted to historical nonsense. She told Auburn, the British American Claims Tribunal's ignorance about the treaty was just about total, as your quotation from the pronouncement so clearly demonstrates. The tribunal knew nothing about the treaty. It made no investigation of the events surrounding the signing of the treaty. In fact, there's no evidence that I recall that the judge was familiar even with the wording of the English version of the treaty, far less that he had a clue of who had signed the actual treaty documents by which she means the Māori text. Ross told Auburn that what he had said in her article was beyond her comprehension because she, as a historian, and he, as a legal scholar, spoke what she called different languages. Keith Sinclair, we know from an article he wrote for the New Zealand Herald in 1990, would have agreed with Ross. Generally speaking, an academic historian will conduct an inquiry into the law to understand what it meant in the past. By contrast, a legal scholar will seek to interpret the law to serve contemporary ends, irrespective of what it might have meant in the past. Yet most academic historians in this country, most importantly perhaps one of this university's most respected and beloved historians, Keith Sinclair, either did not grasp this fundamental distinction or chose to ignore it in the work he did alongside the tribunal from the late 1980s, a matter which I discuss at some length in the third part of my book. What I also want to ask, would Ross have made of the changes in both legal and political discourse and their outcomes in recent times? In other words, had she lived another 15 or 20 years beyond 1982? In all likelihood, I think she would have been astonished by the nature of the reparative work promised by the findings and recommendations of the Waitangi Tribunal in New Zealand's courts. She would have undoubtedly welcomed this change because she was sympathetic to Māori as the dispossessed. But there are some reasons to believe that she might have been troubled by the shifts that have occurred in recent legal and political discourse in regard to the nature of the rights that have been claimed by Māori. Because Ross was of a generation of New Zealanders that believed the losses that Māori had suffered since 1840 were best tackled and a much needed redistribution of goods made on the basis of a reckoning of their contemporary needs rather than claims about historical association or identification that rest in some sense or another on race or culture. In other words, Ross spoke a kind of political language that has largely come to be submerged in New Zealand in recent decades. Furthermore, if Ross was still alive today, she would at the very least be ambivalent about the role that the discipline of history has played in the last 4 or more decades in the production of histories about the treaty in a context that has been dominated by the law and legal discourse. At most, I suspect that she would have been dismayed by the way in which numerous New Zealand historians have been complicit in the production of histories about the treaty that have largely mirrored the story that the law had been telling about the treaty. She would have regarded those stories as myth, and thus as egregiously incomplete historical accounts of the past. There are good reasons to believe that Keith Sinclair would have shared Ruth Ross's misgivings and spoken out accordingly. Thank you.
Thank you.
Oh, thank you. Thank you so much, Bain. That was a very stimulating and intriguing talk. And as I said at the beginning in my introduction, it was very fitting as a Keith Sinclair annual lecture, and I'm sure that Keith Sinclair would have loved to have been here. And I'm going to open it up to questions from the floor, and people can either speak up or put it into the chat box. But before I do, I just want to just make mention to thank the School of Humanities and the Science and Sword Fund for supporting this event, even though in the event it was quite an economical one, I guess, and you'll all be having virtual drinks or drinks in your own private space and food as well. But we still want to thank them for their willingness to support the event. And we do have questions, I know, but I just want to kick it off by mentioning how articles can take on a life of their own. And this is a